Hi, my name is Bruna Frota and I am a US licensed attorney in Texas and New York. If you want to know more about my background and my experience, please visit my website at www.nationalitylawyers.com, and my contact details will also be shared by the end of this video. This is second video for a series of educational videos that I am releasing online, which the first one was about the EB2 and the EB1 self-sponsored green card categories. This video today will focus on the procedural aspects of the adjustment of status or consular filing, which is the final step until before you can get your green card. So the title is called Roadmaps because I will go over the main steps of the process, and this will apply for both family-based and employment-based categories. So I'll not go over the specific subject for each of the green card categories. For that, you would have to rely on and access my previous recorded videos, which the second one will be about the EB2 or EB3 for company-sponsored green cards, where the company will have to do a labor market test and run a labor certification. But for today, we are focusing on the procedural aspects. For any type of green card, the first thing your legal advisor would have to do is make an eligibility assessment on the type of green card you would qualify. And as we have discussed it before, there are so many types of green cards, aka immigrant visas, which involve familial relationship as well as employment relationships with employers, or even related to your wealth or your professional achievements. So again, I'm not going to focus on this today. This is going to be just the procedural aspects. After your legal advisor and you have came down and narrowed down to a few options of your eligibility as far as types of green cards and categories, you filed an immigrant petition or a petition for alien relative, which the most commons are the I-140, the I-130, the I-526. After you file this petition with US Immigration and Citizenship Services, you get a priority date, which is basically your place in line that the government will call you when there is a visa available, meaning a green card available to be issued to you. And that is because statutorily, the Immigration Nationality Act provides a number of visas that are allocated per category and per nationality, meaning country of birth. Because the US government wants a diversity country, not only because there is a number of visas to be issued yearly per category, this is also divided per country of birth. So we're gonna have a diversity society. And then I can go over, of course, the aspects of the employment-based and how this is divided within this main broad category of employment-based green cards. And I'll not go into the family-based because this is not the focus of our presentation today. So after you get this place in line that is called the priority date, and then your date comes on the receipt notice issued by US Immigration and Citizenship Services, also known as USCIS. This is the acronym, is the most easier way to refer to them. You have to select and choose the way you're gonna process your green card. And then the process of the green card application, it is focused on whether you have any kind of inadmissibility issue that would prevent you to become a resident of the United States. So the United States has some set of rules and regulations that does not allow, for example, criminals or people that would be a public charge to the United States to become a resident unless they can overcome this ineligibility and get a waiver. and this, again, this is not the focus of our presentation today. We're gonna go through the most streamlined process for someone that doesn't have any type of inadmissibility. And if the person is inside the US with legal status, with meaning a legal visa and a legal I-94, valid I-94, the person can file for adjustment of status. And there is an exception for employment-based green cards where the person has not been out of status, for example, has not worked for more than 180 days. This person can still file for adjustment of status, and this is under the 245K regulation, the Immigration Nationality Act. And I can also provide some examples of how this play a role in real life. But if the person is outside the US and even the dependents, then this person will process the green card application, aka immigrant visa, directly at a US consulate or embassy. And now I'm gonna go over each of those types of paths with you individually. So the most common type of process, the last step of the green card application, is called the adjustment of status, meaning someone is in the United States with a visa, no immigrant visa usually, and this person is adjusting, meaning she is changing from a non-immigrant to an immigrant visa holder. And this is called adjustment of status, which is different from someone that is applying for a change of status, which is changing from a non-immigrant to another non-immigrant visa category. So for the adjustment of status, the first thing your legal advisor and you have to pay attention to is double check 15 days usually. That's when the visa bulletin is released by the US Department of State. And this visa bulletin is basically the list of people and list of dates, in this case the list of dates that the US government is accepting or processing green cards based on that place in line that I referred to before. So first you check whether USCIS is using the final action dates or the dates for filing charts. Not too long ago, there was only one type of chart in the visa bulletin, which was the final action. But then the US government, saying that there were so many people waiting for the green card applications to be processed in the US and to be able to file and then get the benefit of also applying for unemployment authorization document and the advance parole. They also released dates for filing, which mean that the dates for filing usually are not as backlogged as the final action dates. So USCIS each month will release, as I said, which of the charts they are accepting for the filing of the adjustment of status application. So the adjustment of status application for people that are inside the United States bring a huge benefit, which is, as I said, also applying for an employment authorization document and advance parole, which will allow you and your family members to remain in the US and work and travel internationally while your green card application is pending. That being said, nowadays, the employment authorization document and the advance parole are taking about 7 months from the time of filing for the issuance, and it really depends on the type of visa you have in the US. Unless you have this advance parole to travel internationally, your green card application can be deemed abandoned. So the H-1B and the L-1, for example, are types of visas that are considered dual intent. So even though you travel outside the US without an advance parole, your green card application will not be deemed abandoned. And then, for example, on the other hand, if you have an F-1 student visa and you file for an adjustment of status, but you travel outside the US without the advance parole, then your case will be deemed abandoned. The other thing is, for the advance parole document, even though you may have an H-1B or L-1, The regulations now say that if you travel outside the US while the advance parole document is pending, your advance parole application will be considered abandoned. That's for the initial application, but that's not to be confused with the green card application abandonment. I would not, if you have any specific questions about this, because this can get very tricky and confusing, please feel free to reach out to us and we'll be glad to explain to you. So when you file the adjustment of status application, one of the required documents is a sealed medical report. And now sometimes what has been the practice for a lot of legal advisors is to wait until USCIS requests this sealed medical report from you, and that can be only when you go to your interview, your green card interview, because before 2018, the sealed medical reports were only valid for 1 year. But because of the backlog, a lot of the green card interviews were taking place longer than 1 year after filing. So when people would get to the interview, the medical report was not valid anymore. So people started not to send the medical reports. But now in 2018, the sealed medical report is now valid for 2 years. So now a lot of legal advisors are sending the medical reports along with the initial application. After the application is filed, you're gonna get an appointment to submit your biometrics. Then, as I said, after 7 months or so, you get your EAD-AP combo card, and then at that time, you're gonna be able to work for any employer and travel internationally. Then, depending on where you filed your green card application, and this is based, of course, on your current address in the US, then a USCIS field office will have jurisdiction over your case. Then it really depends on, for example, if you are in Texas or Florida, usually those are states that you have to wait a long time in line until you are called for an interview. Or if you are, for example, in Ohio or states that don't have that many immigrants, usually the interview it's going to be faster. So the waiting time really varies. From there, and of course, there are some types of green cards that don't need a personal interview. For example, if you filed for your parents, usually an interview is not required. But everything else, pretty much, for employment-based nowadays, the interview is a requirement. After the interview, if your priority date, you have to refer as that place in line that I was referring to, is current under the final action dates, then immigration can issue your green card. And as a rule of thumb, if you get your green card via employment, this green card is going to be valid for 10 years. And the green card is like your citizenship. It's your inherent right. It's not just because you don't have a valid green card, or let's say your green card expires, that you no longer have this status. You're going to have the status. The card is just a proof and evidence that you are you are a green card holder. Now moving on to the consular filing roadmap, and again, this is for people that are currently living abroad, or they prefer to process the case abroad. For example, this is very common for my E1 and E2 clients, that they don't want to have the issue of traveling abroad while the green card is pending. They prefer to do the consular filing rather than the adjustment of status. For the consular filing, the agency that will govern and oversee the process of the paperwork is called the National Visa Center. And the National Visa Center will refer to the final action date charge in order to send the initial communication to the foreign national alien in order to start gathering the documentation. So after you receive this communication from the NVC, you have to go ahead and pay for the fee bill. After you pay the fee bill, within 2 to 3 business days, your case is released online, and you can submit the documents either via the NVC portal, or depending on the country that will process your immigrant visa, you might have to send everything via mail to the NVC. Once an NVC receives all the documentation from you and everything is in order, your case is then transferred to the U.S. consulate or embassy that will interview you and process the final documentation as well for you. At that time, once the consulate or embassy schedules your interview, then you have to get your medical report done, as well as submit your biometrics. Then you and your family, you go to the interview. If everything goes well, you get an immigrant visa that is valid for 6 months, single entry, and then you're gonna have to utilize this visa in order to trigger the issuance of your green card once you are inside the United States. Again, the green card for employment-based applicants are usually valid for 10 years, and that can be renewed indefinitely. And if you wanted to apply for naturalization, according to the current regulations, you have to wait 4 years and 9 months and also qualify under other terms and conditions. But then you can also become a US citizen eventually. So after explaining to you theoretically how the process works for the adjustment of status and the consular filing, those are the most important charts that you're gonna have to refer to when making sure whether you're gonna be able to either file for adjustment of status or consular filing, and whether the consulate embassy or even USCIS could process your actual green card. So for USCIS, you're gonna have those two charts that you need to, of course, refer to the USCIS website here, where USCIS will tell you what chart you're gonna have to utilize in order to actually file your application with USCIS. So for example, for the October 2019 filings, people can refer to the dates for filing for both family-sponsored filings and employment-based preference filings, except of course for the family-based F2A. So here, for example, if you are a citizen from Brazil and you are under the first category, you would be able to file your adjustment of status for you and your family if your priority date is July 1st, 2019 or before that date. And in contrast, if you were born in China, for example, then the backlog is much higher, and immigration is only accepting filings for people that get the priority date on September 1st, 2019 or before that date. And remember, this priority date is set when you file an immigrant petition, an I-140 or I-526, or an I-130, which is the petition for alien relative. In contrast, if you are abroad, for example, and you have to go through the consular filing, if you are a citizen from Brazil, the consulate, the NVC, will only issue a fee bill if your priority date is on April 22nd, 2018 or before. What this C means is current. It means that it doesn't matter when you filed your immigrant petition or petition for alien relative, you are still able to file either your adjustment of status or consular filing abroad. So let's say in instance, you are a citizen from Brazil, you were able to file your adjustment of status application in the US. By the time you get to your interview with USCIS, if for any chance your priority date is not current under the final action date, then USCIS will have to hold your application and only issue your green card once the final action date is current or the cutoff date for you is current, okay, meaning available. So this is a very complex area of the regulations, should be understood by the general public. Again, I am available for you, my paralegals, my associates. If you have any questions, we're gonna be glad to answer them. And have a nice day. I hope you enjoy my videos, and the next one will be about labor certification.